Chapter 1 Civil Procedure Subchapter 1 Definitions and General Provisions Article 1 Definitions Section 1 Remedies Remedies in the Court of Justice are divided into Actions 2. Special Proceedings Section 2 Actions Any action in an ordinary proceeding in a court of justice by which a party prosecutes another party for the enforcement or protection of a right, the redress or prevention of a wrong, or the punishment or prevention of a public offense. Section 3. Every other remedy is a special proceeding. Section 4. Kinds of actions. Actions are of two kinds, civil and criminal. Criminal action. Section 5. Criminal action is 1. An action prosecuted by the state as a party against a person charged with a public offense for the punishment thereof. 2. An action prosecuted by the state at the instance of an individual to prevent an apprehended crime against his person or property. Section 6. Civil action. Every other is a civil action. Section 7. When court means clerk. When following sections which confer jurisdictions or power or impose duties, where the words superior court or court in reference to a superior court are used, they mean the clerk of the superior court, unless otherwise specifically stated, or unless reference is made to a regular session of the court, in which cases the judge of the court alone is met. Article 2. General Provisions. Section 8. Remedies not merged. Where the violation of a right admits both of a civil and criminal remedy, the right to prosecute the one is not merged in the other. Section 9. Section 9 has been repealed by session laws. Section 10. Plaintiff and defendant. In civil actions, the party complaining is the plaintiff, and the adverse party is the defendant. Section 11. How a party may appear. A party may appear either in person or by attorney in actions or proceedings in which he is interested. Section 13. Jurisdiction of clerk. The clerk of the superior court has jurisdiction to hear and decide all questions of practice and procedure, and all other matters over which jurisdiction is given to the superior court, unless the judge of the court or the court at a regular session is expressly referred to. Subchapter 2. Limitations. Article 3. Limitations, General Provisions. Section 15. Statute runs from accrual from action. Subsection A. Civil actions can only be commenced within the periods prescribed in this chapter, after the cause of action has accrued, except for when in special cases a different limitation is prescribed by statute. Subsection C. Except where otherwise provided in by statute, a cause of action for malpractice arising out of the performance or failure to perform professional services shall be deemed to accrue at the time of the occurrence of that last act of the defendant giving rise to the cause of action, provided that whenever where is bodily injury to the person, economic or monetary loss, or a defect in or damage to property which originates under circumstances making the injury, loss, defect, or damage not readily apparent to the claimant at the time of its origin, and the injury, loss, defect, or damage is discovered or should be reasonably be discovered by the claimant 2 or more years after the damage after the occurrence of the last act of the defendant giving rise to the cause of action. Suit must be commenced within 1 year of the date of discovery is made, provided nothing herein shall be constructed to reduce the statute of limitation in any action, such case below 3 years. Provided further that in no event shall an action be commenced more than 4 years from the last act of the defendant giving rise to the cause of action. Provided further that there were damages or are sought by reason of a foreign object which has no therapeutic or diagnostic purpose or effect, having been left in the body. A person seeking damages for malpractice may commence an action therefore within 1 year after discovery thereof, a hereinabove provided, but in no event may the action be commenced more than 10 years from the last act of the defendant giving rise to the cause of action. Section 15.1 Statutes of Limitation and Repose for civil actions seeking to recover damages arising out of criminal act. Subsection A. Notwithstanding any other provision of law, if a defendant of a criminal offense and is ordered by the court to pay restitution, or restitution is imposed as a condition of probation, special probation, work release, or parole, then all applicable statutes of limitation and statutes of repose, except as established herein, are told for the period set forth in this subsection for purposes of any civil action brought by an aggrieved party against the defendant for damages arising out of the offense for which the defendant was convicted. Any statute of limitation repose applicable in the civil action shall be told from the time of entry of the court order. 1. Requiring the restitution be made. 2. Making restitution a condition of probation or special probation. Or 3. Recommending the restitution be made a condition of work release or parole. And until the defendant has paid in full the amount of restitution ordered or imposed, except as provided in General Statute 15B-34, an action to recover damages arising out of the criminal offense shall not be commenced more than 10 years from the last act of the defendant giving rise to the cause of action. Subsection B. In any civil action brought by an aggrieved party against the defendant for damages arising out of the offense for which the defendant was conceived. 1. The defendant has the right to contest the amount of damages. 2. The amount of any restitution ordered or imposed shall not be admissible into evidence. And 3. All restitution paid by the defendant to the aggrieved party shall be credited against any judgment rendered in the action against that defendant. Subsection C. This section shall not apply if the offense of which the defendant was convicted was an offense established in Chapter 20 of the General Statutes. Subsection D. A plea of no contest shall be considered in the same as a conviction for purposes of this section. Section 17. Disabilities. A person entitled to commence an action who is under a disability at the time the cause of action accrued may bring his or her action within the time limited in this subchapter after the disability is removed. except in the action for the recovery of real property, or to make an entry or defense founded on the title to real property, or to rents and services out of the real property, when the person must convince his or her action or make the entry within 3 years next after the removal of the disability, and at no time thereafter. For the following purposes, this section, a person is under a disability if the person meets one or more of the following conditions. 1. The person is within the age of 18 years. 2. The person is insane. 3. The person is incompetent as defined in General Statute 35A 111 -1101, subsection subchapter 7 or subchapter 8. Or excuse me, subs 3. The person is incompetent as defined in General Statute 35A. 3. The person is incompetent as defined in General Statute 35A-1101, subparagraph 7 or 8. Subsection A1. For those persons under a disability on January 1st, 1976, as a result of being imprisoned or on a criminal charge or an execution under sentence for a criminal offense, the statute of limitations shall commence to run no longer be told from January 1st, 1976. Subsection B. Notwithstanding provisions of subsection A of this section, and except as otherwise provided in subsection C of this section, an action on behalf of a minor for malpractice arising out of the performance or failure to perform professional services shall be commenced within the limitations of the of time specified in General Statute 1-15, subsection C, except that if those time limitations expire before the minor attains the full age of 19 years, the action may be brought before the minor attains the full age of 19 years. Subsection C. Notwithstanding the provisions of subsection A and B of this section, in an action on behalf of a minor for injuries alleged to have resulted from malpractice arising out of a health care provider's performance of or failure to perform professional services shall be commenced within the limitations of time specified in General Statute 1-15, subsection C, except as follows. 1. If the time limitation specified in General Statute 1-15, subsection C expire before the minor attains the full age of 10 years, the action may be brought at any time before the minor attains the full age of 10 years. 2. If the time limitations in General Statute 1-15, subsection C, have expired before a minor reaches the full age of 18 years, a court has entered judgment or consent order under the provisions of Chapter 7B of the General Statutes, finding that said minor is an abused or neglected juvenile as defined in General Statute 7B-101. The medical malpractice action shall be commenced within 3 years from the date of such judgment or consent order, or before the minor attains the full age of 10 years, whichever is later. 3. If the time limitations in General Statute 1-15, subsection C, have expired, and a minor is in legal custody of the state, a county, or an approved child placing agency, as defined in General Statute 131D-10.2, the medical malpractice action shall be commenced within 1 year after the minor is no longer in such legal custody, or before the minor attains the full age of 10 years, whichever is later. Subsection D. Notwithstanding the provision of subsections A, B, C, and E of this section, a plaintiff may file a civil action against a defendant for claims related to sexual abuse suffered while the plaintiff was under 18 years of age until the plaintiff attains 28 years of age. Subsection E. Notwithstanding the provisions of subsection A, B, C, and D of this section, a plaintiff may file a civil action within 2 years of the date of a criminal conviction for any related felony sexual offense against a defendant for claims related to sexual abuse suffered while the plaintiff was under 18 years of age. Section 18. Disability of marriage. In any action in which the defense of adverse possession is relied upon, the time commuted as a constituting such adverse possession shall not include any possession had against a feme covert during coverture prior to February 13th, 1899. Section 19. Cumulative disabilities. When two or more disabilities coexist at the same time, the right of action accrues, or when one disability supervenes an existing one. The limitation does not attach until they are all removed. Section 20. Disability must exist when right of action accrues. No person may avail himself of a disability except authorized in General Statute 1-19 unless it existed when his right of action accrued. Section 21. Defendant out of state when action begun or judgment enforced. If, when the cause of action accrues or judgment is rendered or docketed against a person, he is out of the state, action may be commenced or judgment enforced within the times herein limited after the return of the person into this state. And if, after such cause of action accrues or judgment is rendered or docketed, such person departs from and resides out of this state, or remains continuously absent therefrom for 1 year or more, the time of his absence shall not be part of the time limited for the commencement of the action or the enforcement of the judgment, provided that where a cause of action arose outside of the state and is barred by laws of the jurisdiction in which it arose, no action may be maintained in the courts of this state for the enforcement thereof, except where the cause of action originally accrued in favor of the residents of this state. The provisions of this section shall not apply to the extent of that a court of the state has or continues to have jurisdiction over the person under the provisions of General Statute 1-75.4. Section 22. Death before limitation expires. Action by or against personal representative or collector. If a person entitled to bring an action dies before the expiration of the time limited for the commencement thereof, and the cause of action survives, and an action may be commenced by his personal representative or collector after the expiration of that time, and within 1 year from his death. If a person against whom an action may be brought dies before the expiration of the time limited for the commencement thereof, and that cause of action survives, an action may be commenced against his personal representative or collector after the expiration of that time, provided the action is brought or notice of the claim which action is presented to the personal representative or collector within the time specified for the presentation of claims in General Statute 28A-19-3. If the claim upon which the cause of action is based is filed with the personal representative or collector within the time above specified, and the validity is admitted in writing by him, it is not necessary to bring action upon such claim to prevent the bar, but no action shall be brought against the personal representative or collector upon such claim after his final settlement. Section 23. Time of stay by injunction or prohibition. When the commencement of an action is stayed by injunction or statutory prohibition, the time of the continuance of the injunction or prohibition is not part of the time limited for the commencement of the action. Section 24. Time during controversy on probate or will or granting letters. In reckoning time when pleaded as a bar to actions, that period shall not be counted which elapses during any controversy on the probate of a will or granting letters of administration, unless there is an administrator appointed during the pendency of the action, and it is provided that an action may be brought against him. Section 26. New promise must be in writing. No acknowledgment or promise is evidence of a new continuing contract from which the statutes of limitations run, unless it is contained in some writing signed by a party to be charged thereby. But this section does not alter the effect of any payment of principal or interest. 27. Act admission or acknowledgment by party to obligation or co-obligator or grantor. Subsection A. After a cause of action has occurred on any obligation on which there is more than one obligator, any act, admission, or acknowledgment by any party to such obligations or grantor thereof, which removes the bar of the statute of limitations or causes the statute to begin running anew, has such effect only as to the party doing such act or making such admission or acknowledgment, and shall not renew, extend, or in any manner impose liability of any kind against other parties to such obligation who have not authorized or ratified the same. Subsection B. Nothing in this section shall be construed as applying to or affecting rights or obligations of partnerships or individual members thereof, due to acts of omission or acknowledgments of any one partner, but rights as between partners shall be governed by General Statute 59-39.1. Section 28. Undisclosed partner. The statutes of limitation apply to a civil action brought against an undisclosed partner only from the time the partner became known to the plaintiff. Section 29. Co-tenants. In an action by tenants and common or joint tenants of personal property to recover the same or damages for its detention or injury of any of them are barred of the recovery by limitation of time. The rights of the others are not affected thereby, but may recover according to their right and interest, notwithstanding such bar. Section 30. Applicable to actions by state. The limitations prescribed by law apply to civil actions brought in the name of the state, or for its benefits in the same manner as to action by or for the benefit of private parties. Section 31. Action upon a mutual open and current account, and an action brought to recover a balance due to a mutual open and current account where there have been reciprocal demands between the parties. The cause of action accrues from the time of the latest item proved in the account on the other side. Section 32. Not applicable to bank bills. The limitation prescribed by law do not affect actions to enforce the payment of bills, notes, or other evidences of debt issued or put in circulation as money by banking corporations incorporated under the laws of this state. Section 33. Actions against bank directors or stockholders. The limitations prescribed by law do not affect actions against directors or stockholders of any banking association incorporated under the laws of this state to recover a penalty or forfeiture imposed or to enforce a liability created by law, but such actions must be brought within 3 years after the discovery by the aggrieved party of the facts upon which the penalty of forfeiture attached or the liability was created. Section 34. Aliens in time of war. When a person is an alien subject or a citizen of a country at war with the United States, the time of the continuance of the war is not part of the period limited for the commencement of the action.